What if the Richmond land claim never went to court at all? What if governments chose a negotiation instead of risking a judicial loss? In my video on the Cowichan ruling, I mentioned that a treaty or land agreement could be one of the possible outcomes of that ruling. The Haida Gwaii Agreement is the clearest, most advanced example we have of what that path could actually look like. Before I get into it, if you want to stay up to date on what's happening in BC's real estate market, make sure you hit that subscribe button. And if you're curious as to how these rulings affect your specific situation, there's a calendar link below. I'd be happy to go over it with you. What we're looking at today is historic, but also legally mind-bending. On one hand, the Haida has achieved official recognition of Aboriginal title over the terrestrial land that is Haida Gwaii, which is enormous. It's one of the most sweeping recognitions of Indigenous title in Canadian history. But on the other hand, governments are giving absolute assurances that private property rights remain completely untouched. Those two things don't exactly sit comfortably together. How could the Haida Nation hold exclusive title over the whole island, while a homeowner holds exclusive title over their plot of land on the same island? Is this the brilliant future of reconciliation, or is this just another property law nightmare waiting to happen? It's the question of the decade for property law here in BC. On September 5th, 2025, the Haida Nation achieved official historic recognition of Aboriginal title. Not just a specific site or a single resource, but to the entire area of their homeland. And when we say that, what are we actually talking about? We're talking about the entire landmass of the islands, roughly 10,000 square kilometers, or about 2.5 million acres. This came through a landmark order of the BC Supreme Court. But the most important detail is not that the court issued this declaration, it's how. It was issued by consent from both British Columbia and Canada. That distinction changes everything. This wasn't a judge imposing a decision after a long adversarial trial. This was a negotiated outcome. And it's the first time a BC court has ever issued a declaration of Aboriginal title covering an entire Indigenous territory like this. This wasn't a legal accident. It was a political response to legal risk. Governments have been watching Aboriginal title cases closely, and the trend line is clear. So instead of rolling the dice on a 20-year legal battle that they might potentially lose anyways, the province decided to negotiate. That negotiation produced two major agreements after more than 5 years of talks. One with BC in April of 2024 called the Rising Tide Agreement, and one with Canada signed in December of 2024 called Big Tide Low Water Agreement. Together, these agreements allowed the parties to move from shared decision-making into actual recognition of title. The stated goal was stability, managing a transition from a colonial governance to a Haida jurisdiction without everything falling apart. Culturally and politically, it's a massive success. It avoids decades of potential litigation that the government might have lost anyways. So why not cut a deal? But for anyone who owns property or lends against it, the real story starts in the mechanics. To understand how we got here, we have to go back to 1985, the blockade on Lyle Island. Elders, chiefs, and matriarchs physically standing in front of logging trucks on a muddy road to stop clear cutting on unceded land. 72 people were arrested, and these weren't symbolic arrests. These were criminal charges. And the irony there is impossible to ignore. The people arrested in 1985 were told 40 years later that they were the actual owners all along. The so-called criminals were actually the landlords. There is a detailed and fascinating documentary about this blockade called The Stand. You can watch it for free, and I've included the link to it in the caption below. It's worth watching if you want to understand what that actually looked like and what the media coverage was of it at the time. The Haida always maintained that there was no land lying vacant. The idea that if you didn't build a farm or put up a fence, the land was just empty and up for grabs was never accepted. Every inch was known, named, and stewarded. So to cut to the chase, the blockade worked. It stopped logging on Lyle Island, and it eventually became a park reserve. But the Haida didn't stop there. In 2002, they filed a writ seeking title to the entire territory. And this is a key part. They didn't just sit in court for 20 years. This was a dual track strategy. While lawyers were filing motions, The nation was building governance, negotiating with the province, and proving in real time that they could manage the land and resources. That long pressure cooker is what made the Rising Tide Agreement possible. Now, let's talk about the plumbing of that agreement, because this is where things get uncomfortable. In Western property law, fee simple is the highest form of ownership. It's the castle doctrine: exclusive use and occupation. You can keep people out, sell it, mortgage it, give it to your kids, whatever. Aboriginal title, according to the Supreme Court of Canada, also confers exclusive use and occupation. You see the problem. If the Haida have exclusive title over the whole island, and a homeowner has exclusive title to their lot on the island, you have two exclusive rights occupying the same legal space. That's a logical impossibility. It's like two people both claiming the same winning lottery ticket. The Rising Tide Agreement tries to solve this by saying that the Haida Nation consents to and will honor existing fee simple interests. That word consent is doing a lot of work. And what are the risks involved there? Can consent be withdrawn? Legal scholars are debating that exact question right now because we are in completely uncharted territory. This was a declaration of title by consent. The Crown never fought it in court. Compare that to the Cowichan case, where the government is fighting both tooth and nail, arguing that Aboriginal title and private property cannot coexist. Two opposite legal positions in two courtrooms at the same time. And this is where some legal skeptics get nervous, because consent implies power. If I consent to you staying in my house, I also have the power to withdraw that consent, even if I promise I won't. So while governments are telling homeowners not to worry, something has fundamentally changed. But I'm going to say this twice for clarity. Private property held in fee simple interest is not impacted today, and it still remains under provincial jurisdiction. The Haida Nation was very clear and very public about that commitment. Local governments stay the same. Bylaws, zoning, business license, property taxes all continue under BC law. Roads, ferries, schools, hospitals, emergency services all remain provincially operated during this phase. On paper, nothing changes day to day. But in law, words matter. The uncomfortable truth is that the Rising Tide Agreement is a contract, a political deal, not a treaty. Treaties are constitutionally entrenched. Contracts are not. Private landowners are not party to this agreement. They didn't sign anything. They're relying on the province to defend their interests in a deal where the province has already acknowledged that the Haida has the underlying title. That's where the concept of cloud on title comes in. A cloud on title doesn't mean someone is taking your home. It means uncertainty about who ultimately controls the land and how it can be dealt. And when uncertainty creeps in, banks and insurers get nervous. Lenders need to know that if a borrower defaults, they can seize and sell the asset cleanly. Markets run on confidence. When confidence shakes, values drop, even if nothing has changed on the ground. This is where the Cowichan case re-enters the picture. In the Cowichan case, which, to be clear, is under appeal and factually different, the court suggested that Aboriginal title could be legally superior to fee simple private property. That creates a direct tension. On one side, you have political assurances that private property is safe. On the other, you have evolving case law suggesting that those assurances may rest on negotiation, not constitutional certainty. So the government is effectively saying, the Haida own the land, the Haida agree you own the land, so let's all just get along. And the Haida situation is unique, so it may work perfectly there. But if applied to other areas, it could be a massive trust exercise. And trust exercises are hard when your entire life savings are tied up in them. David Eby was quoted suggesting that this could be the template for other areas. But then almost immediately the government tried to walk back on that. And they walked back on it for that reason that I just mentioned, because the circumstances on Haida Gwaii are incredibly specific. The government argues it's unique because it's on an island. The borders are defined by the ocean. It's clear, and unlike the rest of BC, there are no overlapping claims. On the mainland, you might have 3 or 4 different nations claiming the same spot. In Haida Gwaii, it's just the Haida, so it's much cleaner in a legal sense. But the legal engine driving this, UNDRIP, it applies everywhere in BC. So this is not a one-off idea, it's a directional shift. This is a move from colonial property law toward a reconciled model, a relationship-based system where ownership becomes something negotiated between governments rather than issued cleanly by the Crown. And it could potentially work. If the transition is smooth, predictable, and stable, markets may adapt. The Haida have co-managed resources for years without economic collapse. But holding title to someone's backyard hits a different nerve. Home ownership is usually the biggest investment a person ever makes. It's retirement, and in some cases it's a legacy. It's deeply personal. So here's the real conclusion. The Haida Agreement shows that private property and Aboriginal title don't have to collide in court. If the government does their job properly during negotiations, early, honestly, and with real legal clarity, private property rights can be protected through agreement rather than denial. In the Cowichan case, that outcome is still possible. But this experiment also carries risks. We are traded the rigid certainty of an old system for a more fluid relationship-based one. The government is betting that reconciliation can do the work the law used to do. If that bet succeeds, this could be the new model. If it fails, if uncertainty leads to capital flight, lending pullbacks, or falling property values, it could set reconciliation back by decades. The official line from everyone, the province, the Haida, the feds, is that fee simple ownership is safe. They promise it. But if your ownership now depends on consent from a third party rather than just a right granted by the Crown, have we fundamentally changed what it means to own something in BC? Let me know what you think in the comments below. That's a question that we hope to have answered sooner rather than later.